Good evening, ladies and gentlemen. It's great to see such a large crowd here this evening for this lecture. On behalf of Dr. Ursula Kilkelly and I would like to warmly welcome all of you here tonight to this evening's lecture, which will be delivered by the Honourable Mr. Justice William McKechnie on a lecture entitled Respectable Criminality. As some of you might be aware, this is the fourth distinguished lecture in the series being delivered here in the Centre for Criminal Justice and Human Rights. The first three having been given by Professor Conor Gearty of the London School of Economics, Judge Navin Pillay, United Nations Human Rights Commissioner, and Mr. Guy Goodwin Gill of All Souls in Oxford. Since its inception in 2006, the Centre for Criminal Justice and Human Rights here in UCC has really grown from strength to strength in terms of research, teaching, postgraduate supervision, and community impact. Staff in the Centre have engaged in the publication of books, in the publication of articles in international journals, in the organisation of national and international conferences. They have been successfully tendered for research funding. They have contributed to government reports, and they have also engaged in dynamic teaching, particularly on our clinical master's programme, the first of its kind in the country, but also on our law and citizenship programme that operates in Cork Prison. There are a number of people that I would like to thank for organising tonight's event, and without whom it wouldn't actually been possible for this event to take place. In the first instance, I would like to thank my Head of Department and Dean of the Faculty of Law, Professor Steve Headley, who has been a great supporter of the Centre for Criminal Justice and Human Rights, and also a great supporter of all the individuals in the Centre. I must also thank Professor Irene Lynch-Fannin, who is the Head of College of Business and Law. She's also been a great supporter of the Centre for Criminal Justice and Human Rights, and I know she has a keen research interest in this evening's topic. My colleagues in the Centre, and indeed in the faculty more generally, also deserve mention. They continue to excel in their teaching and in their research, and they make it a real pleasure and indeed a privilege to actually work in this law faculty. Finally, there's a number of people that I need to mention particularly. Miss Noreen DeLee is the person who has organised the event, and she's the person who brought us all together here this evening. She's organised the Aula Max, the wine reception that's to take place afterwards. She's worked tirelessly on this for the last 3 months, and so I think she deserves special mention. And in addition, I would like to thank other people who have contributed tonight: Mr. Patrick Rice, Miss Susan Leahy, Margaret Fitzgerald, Mary O'Regan, and Anna O'Sullivan. On to tonight's topic. The topic, as I mentioned earlier, is respectable criminality. There's been considerable discussion over the last 18 to 24 months on this issue of white-collar wrongdoing and on the need to reform our regulatory infrastructure. Some people suggesting that we should move from a principle-based model to a more rule-based model, or away from a compliance-based, enforcement mechanism to one based more on a sanctioning model. I don't know where we are on that continuum, but I think one thing is clear. For the past 200 years, our criminal justice system has been preoccupied with crime in the streets. That is, the homicides, the sexual offences, the assaults, criminal damage to property, and so on, and has tended to ignore crime in the streets, the former being viewed as mala in se, or morally wrong, the latter is merely mala prohibita. And I think that may have been a mistake for a number of reasons. First, our criminal justice system is founded on the notion that public protection and security are essential goods which are necessary for our self-preservation, for our well-being, and for our happiness. I don't think that such a proposition is contentious. What is striking in Ireland, however, is that the perception still exists to some extent that white-collar crime doesn't pose a threat to our security. And to date, we've adopted a very, narrow understanding of what constitutes a threat to our security in society. Fastened, to a very traditional outlook that views white-collar wrongdoing as having rather benign effects. And I think, we need to quickly adopt a much more nuanced understanding of security and how it can be threatened. And with that as well, we need to jettison traditional thinking on white-collar crime. Secondly, if we recognise that white-collar crime or regulatory crime has serious consequences, then I think we also need to recognise that a compliance-based model of enforcement alone cannot best guarantee our security. It needs to be supported in addition by a sanctioning model that would include the use of imprisonment. I think to suggest otherwise would be to endorse a two-tier system of justice, something which would make a mockery of our notion of equality of all citizens before the law. Finally, I think we should not underestimate the powerful cathartic effect that the proper use of criminal law can have in our society. In addition to its ability to convey a powerful moral message, it can also act as a platform for the expression of collective sentiment or collective outrage. And this is something which a sociologist by the name of Emil Durkheim would say limits the demoralizing effects that the consequences of serious wrongdoing can have in our society. Now, in saying this, obviously we shouldn't use the criminal law to scapegoat or to promote intolerance or repression, but it can be used as a conduit for the expression of collective outrage, albeit within a jurisprudentially constrained environment. The threads that I've just mentioned, all of these were raised in a judgment delivered by Mr. Justice William McKechnie in March 2009 in a case called the People DPP versus Duffy, in which he was building on an earlier case, the People DPP versus Manning. The case involved competition law abuses, and in particular related to an association of Citroën car dealers. I read the judgment when I was in the States in April 2009, and I was immediately struck by what I thought was the significance of the judgment, the compelling insight that it offered. And I was in communication with Mr. Justice McKechnie shortly thereafter, and I suppose I'm just honoured and thrilled that he could be here tonight to share more of those insights with us. It's almost time for me to exit the stage. The last thing I need to do is to introduce my good friend, Dr. David Riordan, Judge of the District Court, who has kindly agreed to chair this evening's lecture. Dr. Riordan has been a judge of the District Court since 1995, and he currently sits in Cork City District Court. He is an editorial member of the Judicial Studies Institute Journal. He's also on the District Court Rules Committee. He has a very active interest in research, particularly on criminal justice and sentencing. And last September, he wrote a quite brilliant doctorate on the use of community service orders and suspended sentences in Ireland. So he's been a great friend to the faculty and to the centre, and I'm delighted to introduce him to you now as the chair. Thank you very much.
Thank you very much, Shane. As Mike is alive, is it? My function here is to act as chair, and without further ado, I just want to address a few sort of housekeeping issues. First of all, as a reminder, would you just pull out your mobile phones and turn them off, please, in case they go off mid-voyage, as it were. Secondly, to indicate that at the conclusion of the lecture, there will be an opportunity for questions and possibly answers, and following that, there will be a wine reception in the common room to the west of us here. To begin, therefore, I want to introduce Mr. Justice Liam McKechnie, who is a distinguished judge of the High Court. Previously, Liam McKechnie was chairperson of the Bar Council of Ireland. He holds a master's degree in competition, European law, and has been the assigned judge, both civil and criminal, in relation to competition issues since 2002. And perhaps it is well to remember that competition law is, on the criminal side, is tried in the Central Criminal Court, a court which deals in the main with murder and rape, and has other reserved sins like piracy, genocide and high treason. But in the mix, oddly enough, is breach of the competition law. So whatever the Oireachtas had in mind in putting the breach of competition law into the Central Criminal Court as opposed to reserving it or keeping it as one might expect otherwise in the Circuit Criminal Court. Well, I think that might be regarded as a state secret. Perhaps we'll get some further insight into that tonight. The title to this evening's lecture is Respectable Criminality. And when one reflects upon the type of case that normally presents in the Central Criminal Court, I wonder, is it some kind of a reverse indication as to what we might expect in this lecture here this evening? We shall see. I want to introduce to you now Mr. Justice Liam McKechnie of the High Court.
Thank you, Dave. Good evening, ladies and gentlemen. At the outset, may I express my deep appreciation to the Centre, and in particular to Dr. Kilcommins for his kind invitation to deliver this lecture. This Centre, as you may know, has now been in existence for some time, and it has an international presence which indeed it can be very proud of. May I also express my appreciation for your attendance here this evening, and I'm grateful, I think, to recognise so many of you in the audience. It's an absolute honour to be in the Aula Maxima to deliver this lecture, and I could not have foreseen this, I think, when some 40 years ago I scrambled across the squad, frantically scattering bodies and souls alike, trying to get to the notice board to see whether or not my exam number was there and whether the result was thumbs up or thumbs down. It's a time that I have long forgotten, but home is home, and I have never forgotten UCC. So I'm delighted to be here this evening. When deciding on this precise topic for presentation, I was given a broad discretion by Dr. Kilcommins, for which I'm grateful. As a result, I declined the challenge to engage in any substantive part or principle of criminal law, and instead, because of my undoubted respectability, high social standing, and occupational position, I decided to concentrate on something more abstract and obscure. As I start on this process, I dearly hope that such decision will not turn out to be a major embarrassment. My interest in this area is secondary to my role as judge in charge of the competition list. By far and away, the vast majority of such cases coming before the courts are civil in nature. But since 1996, and in particular since the Competition Act 2002, certain coordinated activity between actors, as well as abusive conduct by economic operators, was criminalised with significant sanctions. Therefore, in the last few years, I've presided over a number of criminal trials in the Central Criminal Court. As antitrust activity is undoubtedly the eldest son of both Mr. and Mrs. Whitecollar, I have developed a keen interest in this subject. The former title, as Dave has said, is Respectable Criminality, though in fact it could have been renamed Posh Criminality, or the contest between the Armani and the Kappa, or the whereabouts of the have and have-nots. In truth, the topic is now almost traditional and will be known to you as white-collar crime. In going through this lecture, I propose to discuss it by reference to a number of questions, in fact 6 in all. Rightly or wrongly, ladies and gentlemen, I have deliberately decided against PowerPoint, but as a relieving gesture, I am committed to this lecture lasting no more than what it will, however long that might be. Before I outline the questions, could I just ask for your indulgence in one matter? As you know, I still sit in the competition court, and as such, this type of case might frequently come before me at some point in time in the future. As such, I am not in a position to freely express my views as otherwise I might if I was not engaged in this type of law. So therefore, I do ask your forgiveness in that regard, but please bear it in mind as I go through what I consider to be this very interesting topic. The 6 questions by which I propose to take you through this are: what do we define as white-collar crime? Who commits white-collar crime? Why do people commit it? Are there victims or no victims? Punishment. Should it be civil, regulatory, or should it be criminal? And finally, where from now? What does the future hold? In fact, this list of questions could usefully be added to by matters such as how such crime is discovered, how it is investigated, what are the decisive factors in deciding to prosecute or not, and if time permitted, to take you through what might be a typical trial on the issue of liability in the Central Criminal Court. However, it is unlikely that in the time available, much concentration can be focused on those items. A little bit about the background. The phrase in question was coined about 60 years ago, but the genesis of white-collar crime has been with us since millennia. Aristotle, who was born about 2400 years ago, described embezzlement of funds by the road commissioners. The Athenian constitution in the 5th century spoke of theft of public monies and indeed imposed a sanction of requiring the culprits to pay 10 times the amount that he or she had taken. Ancient religious texts also condemn a number of exploitive business practices as harmful, and although not criminal, quite significantly and well before their time, they were certainly condemned as immoral. For example, in its first written compendium published in 2000 or in 200 CE, it was stated thus: the Talmud exorcised those who hoarded food in order to resell it at a high price, tampered with weights and measures, and raised prices unjustly. In the late Middle Ages, the English Parliament brought in crimes against regrating, engrossing, and forestalling because those activities sought to control important markets with regard to certain commodities. Each of those offences was a pre-runner to, in fact, antitrust and competitive offences as we know them today. Crimes committed by persons considered respectable and honourable by reference to their behaviour and conventional conduct have drawn the attention of societies throughout history. In 1890, the first serious attempt was made in the US by the passage of the Sherman Act to criminalise antitrust activity. That act created a cartel offence and also made monopolising the market a felony. Justice Stone from the US Supreme Court spoke of the underlying reason for this some 50 years later when giving judgment in a case called Apex Hosiery. And he identified 3 matters in particular which well justified the passing of that act. First was the fact that capital was organised, and organised within a very tight and small area. Secondly, that marketing and the supply of goods was controlled, and again tightly controlled. And thirdly, that on the markets where goods and commodities were traded, competition itself was suppressed. I would recommend to anybody who would have the time to in fact read that judgment in its entirety. In any event, E.A. Ross, the noted American sociologist, links such activity nicely to the definition I'm about to mention. In his famous Sin and Society publication in 1907, he castigated what he described as the criminaloid, that is, powerful business owners and executives who exploit people and manipulate the marketplace out of an uninhibited desire to maximize their profit, all the while pretending to be pious and respectable. You can instantly see the 2 sides of the same coin: the exploitation and the outward appearance of being pious and respectable. His pen, however, did not stop there. He also castigated as a further scourge on society the man who picks pockets with a railway rebate, murders with a nadulant instead of a bludgeon, burglarizes with a rake-off instead of a jimmy, cheats with a company prospectus instead of a deck of cards, or scuttles his own town instead of his ship. So undoubtedly the type of crime we're going to discuss this evening has been in existence for some very considerable time. But like many other topics, until it was given a catchy or memorable title, it did not receive the attention which is presently focused to it. In our area tonight, ladies and gentlemen, the true debate started in 1939. The first question relates to definition. What do we define as white-collar crime? Is it by reference to he who commits, or the nature of the offence, or the opportunity of committing, or the status or perceived, or the status, whether perceived or actual, of the culprit? I will ask, is it possible to have any acceptable definition? And even if it is, what should such a definition be focused on? Despite the long established existence of such conduct, what remains the bedrock of this topic is a paper presented by E.H. Sutherland in 1939, in which for the first time the phrase white-collar crime was coined. Before I refer to that paper in any detail, could I suggest that attempting to define the phrase as distinct from identifying a particular crime within it is very much like describing an elephant. If it were possible to get a fairly instantaneous printout of your views as to what might be an acceptable definition of white-collar crime, I suspect that many of you would differ, and perhaps substantially so, as to what that definition might be. If that is so, Mr. Sutherland's attempt may further indeed surprise you. He described white-collar crime as a crime committed by a person of respectability, high society, and in the course of employment. Many people instantly regretted that definition, lawyers and businessmen taking the view that it was misleading, whereas his fellow social scientists acclaimed it as being a landmark. I suspect that both groups were in fact partially incorrect, and both spoke too loudly. With regard to the businessman and the lawyer, it seems to me that the changes in society and as its underlying values evolve, together with the appreciation of the harmful cost of thievery in all its forms become more acutely felt by lawmakers, the less utility the lawyer has for this definition. It is now also believed that despite previous public utterances, the definition by Mr. Sutherland was not designed for practical application in the legal world, but in fact was a social concept, and so describing it. Viewed from that point of view, its frailties, which undoubtedly exist, and its enigmatic nature can be overlooked. Whereas, in fact, viewed from the point of view of the lawyer or businessman, certainly with enforcement in mind, such definition could not afford the same level of forgiveness. Sutherland in 1939 hypothesized that white criminals had different characteristics and motives when compared to this typical street criminal. Although before his research, which led to that paper, there was no previous empirical correlation between crime and high society. Building on that 1939 lecture, he subsequently published a book a decade later, which dealt solely with large corporations and public utilities, in which he documented in detail derelictions by corporations, which, unflatteringly, he compared to conmen and robbers. His identification, however, of this area of the law as distinct from what might be considered blue-collar crime or ordinary criminality was pioneering in his time and has led to significant greater probity on this topic. He argued strikingly as to why it was that corporate executives and senior managers escaped prosecution and sanction, and even if sanction was imposed, it most certainly did not include incarceration. This when compared with what the street criminal day-to-day faced. He opined that white-collar criminals did not perceive themselves to be criminals, and even when their violations were patently criminal in nature, they denied any such categorization. He said that they were comfortable in the belief that they ought not to be associated with any other class of criminal, and that in fact what they were doing could not be so described. Indeed, at the time, as judged by their reaction and conduct, a great number of influential members of society likewise agreed with that. It is not possible in this talk to scrutinize his definition in any great detail, but mention should be made of some of the difficulties which have paved its use. These may be split broadly into three categories: inherent problems with the definition, causes, and regulation. His definition could not be said to be criminal or violation specific. Rather, it embraced the deep-felt concern of the combined effect of trust, authority, status, and position when used to abusive ends. Two of the main contentions with his definition are firstly his assignation of certain activity as criminal, and secondly whether its main focus should be equally distributed between the triumvirate of status, occupation, and organisation, or whether in fact the element of status should be redesignated. In his book, which I've said was published 10 years later, he argued that in many core respects Mr. White-Collar displayed the same characteristics as a professional thief, in that his action, frequently repeated, was pre-planned and executed with precision-like coordination. Respect for the law, the Mr. White-Collar man did not have. Sutherland argued at the time that if class, influence, and power did not prevail, then corporate violations of regulatory rules and administrative rules would be included within offences as defined by traditional criminal law principles. He found that the causative reason for excluding such activity was influence gained through respectability, status, and position, which he rejected. And hence he went about, in that paper, enhancing the definition of criminal acts and extending the boundary enlargement of what was traditionally considered to be included in that area. That was quite controversial at the time and remains controversial some 70 years later. The second issue, probably more eye-catching, referenced status, which together with occupation he deliberately included in his definition, so as to distinguish firstly crimes associated with respectable or legitimate persons from ordinary crimes, even those committed by such high-status individuals. And secondly, he also distinguished between crimes committed in the ordinary course of business and organised crime. Although white-collar crime is often associated with the crimes of senior management and executives, occupational crime itself is likely to be committed by a broad social category. Customers and employees can be defrauded by junior or senior sales personnel. Corporate executives, secretaries and porters can sell inside information, and people lie, cheat, or commit acts of omission through occupational hierarchy. Similarly, although Sutherland and the concept in general focuses on major corporations and large businesses, small and medium-sized businesses can equally engage in offences against consumers, employers, employees, and the environment. So it might therefore be argued, in the light of that the high social status element of his definition should be removed, and that there should be a realignment of crimes committed within the course of employment. One might call them occupational crime or economic crime, or crimes committed on and by way of abuse of occupational trust. However, my view to take such a step would be to remove what many see as a key component of the concept, and in the process to merge his consideration of theory with that of mainstream criminology. It would also, if you were to remove that concept, drastically expand the category of offences which would fall into it, and that in itself would divert focus from the unique aspect and attitudes which was under consideration by him. Without the inclusion of that element in 1939, developed further by his book 10 years later, I doubt strongly if even today, despite our recent experiences, law enforcement agencies and legislators would have the same concern and interest in this topic as they presently have. So, that catchy and memorable title has led to a generalized debate within society as to what white-collar crime is, what it costs, how to be dealt with, how people who commit it should be treated and looked upon, and so forth. His definition, however, was not particularly helpful as a practical description of the topic. As already pointed out, the type of activity referred to by him could be committed by people who could never be classified as being at that level or at that end of social standing. In principle, it's difficult to see how tax fraud committed by a corporation or an executive could be treated any differently from tax fraud committed by a person who could not be said to be of the high socio-economic status. Even if there should be a principal difference between both sets of people, and there might, for example, motivation, greed as against poverty, the courts could never develop one line of jurisprudence for the rich and another for the poor, regardless of who might benefit from such development. So therefore, many other bodies, academics and commentators, sought to dismember and reassemble a definition of white-collar crime. Several have published their resulting works. This process is ongoing as we speak even. In particular, I simply want to mention two. A definition by the US Justice Department, as you might gather, and a description of it by the United States Chambers of Commerce. It's unnecessary to refer to either in any detail. It's sufficient to say that both lack inclusivity. The Justice Department definition requires the perpetrator to be professional or semi-professional or to have special skills. Not all white-collar criminals have or fall within this bracket or have these traits. Likewise with the Chamber of Commerce, some classic white-collar crimes do not involve deception, for example bribery and extortion. And a striking example is competition violation, which have always been considered to be amongst the most classic of all white-collar crimes. So, in the absence of a comprehensive definition, of which I don't believe there is one, could I give some examples perhaps of what's not included within the generally accepted meaning of white-collar crime? Any crime associated with force or threatened force is excluded. Crimes involving the possession, sale or distribution of drugs are likewise, as is organised crime, matters relating to immigration, civil rights or national security, or those directly involved in vice crimes or common thefts have always been accepted not to fall within the definition. So, as we speak, whilst considerable effort and research and academic thought has gone into this process of trying to identify a working and serving definition of white-collar crime, the same has yet eluded us. As with the definitional problems associated with this paper, there's also some ambiguity about causes. Why do persons of ostensible means jeopardize their livelihood by knowingly committing criminal acts? Some have posited that such persons are just bad apples in the barrel, and as such there is no general culture of white-collar crime as there might be in relation to blue-collar crime. Sutherland himself sought to find some explanation to this question, ultimately suggesting that it was a combination of what he described as differential association and social disintegration. Differential organisation is a concept well known to you all, but it has this title as given by him in his paper. He said, it is the idea that behaviour is learned from people or a class of people with whom a person associates. And in particular, if that person already practices some illegal behaviour. then the associatee will learn from that. And both will be segregated from frequent and intimate contact with law-abiding behaviour. And thus, in that way, they will perpetrate the activities which I have ascribed to them. In practical terms, it means that a street criminal may have learned such behaviour through associating with delinquents, or as is commonly put, the wrong crowd. And he thus differentiates himself from the law-abiding person in that regard. On the other hand, Mr. White Collar may come from a good home, a good neighbourhood, graduate from college, but find himself in the practical world of business where he is inducted into a culture. That culture, to the exclusion of those who are not in the business world, renders him who he is, or at least in part explains what he is. In business, certainly in the past, and largely true of the present, the rules of the game may conflict with legal rules, competition rules, with the latter frequently, unknown to most, yielding to the former. A businessman who wishes to obey the law may be driven by his competitors to adopt their methods, or else fail. There are other causes which are inherent in Mr. Sutherland's paper, which should be mentioned. Some have suggested, as causes for white-collar crime, the criminogenic nature of corporations, or even capitalism itself. The inherent dispersal of responsibility within an organisation can mean that no one actor truly accepts responsibility for his actions. This can lead to criminal omission through laxity, or else to criminal commission due to a feeling that actions were carried out because they were ordered, or that they were necessary in the interest of company. And of course, if they were necessary in the interest of company, they were justified. With regards to capitalism in general, it has been argued that the focus on competition means that pressures are inherently placed on individuals to continuously outdo their competitors by whatever means, lawful or unlawful. Further, the overriding goal of profit means that persons are driven towards acts of greed. This is a topic I will just refer to again a little later. Despite these observations, as I'm sure you will all agree, there must be a variety of causal factors at play in any given crime. So it would therefore be wrong to suggest that there is ambiguity, for example, in the crime of assault simply because assault may have been committed for different or conflicting reasons. The nature of the regulatory legislative regime used also gives rise to a level of ambiguity. Some feel that such activities should more properly be dealt with through regulation. Others now push for increased criminalisation. There may now, more so than at any period in the past, be more of a social consciousness of the ills of white-collar crime in light of the financial meltdown which occurred only a short time ago, and which still continues. In most people's minds, this depression is undoubtedly the fault of white-collar criminals who, they feel, may never get their just deserts. Arguments advanced by Sutherland that people still do not consider those acts as morally wrong, or are otherwise ambivalent or contrary towards them, may not ring true today. Furthermore, the criminal law is an evolving beast. Society is constantly changing and discovering new ways in which to circumvent existing laws, or new ways to commit new crimes for that matter, especially when one takes technology into account. The challenge facing the criminal law is that it must keep pace, it must keep abreast. And if it can carry with it the morals of its population, it will be most effective. Where once there was apathy and acceptance of drink driving, to give you one example, there is now generally an abhorrence. It is something not to be done, and even more so not seen to be done. It is therefore only through repeated exposure of such acts that they may become less socially acceptable. When people ultimately see the extent to which some white-collar criminals have enriched themselves at the expense of others and the public at large, they cannot but see that their acts are criminal and ought to be so categorised and ought to be so treated, not only in the criminal context but also in the social context. In any event, the fact that an activity has not always been a crime, or because previously it has been dealt with either as a regulatory offence or otherwise, does not mean that it should so remain. The criminal law is in many respects merely a reflection of changing societal standards. Cartel activity, for example, was only truly criminalised in this country in the last 20 years. However, notwithstanding that, the court in DPP v Duffy, judgment delivered a year ago, was able to describe such activity as being offensive and abhorrent, not simply because it is malum prohibitum, but also because it is malum in se. Such activity is antisocial in every sense. Cartels are conspiracies, and carteliers are conspirators. Nonetheless, in business, there's always been a constant presence of duplicitous persons who in their personal life outwardly appear to be upstanding members of the community. They go to church, they commit to charitable causes. They would never commit a violent crime or physically enter a house and steal therefrom, yet who in their business life engage in acts deliberately designed solely to maximise profit at the expense of consumers, competitors, or even employees. These people, generally speaking, are not thought of as criminals by those who know and work with them. As previously stated, they certainly do not treat themselves or think of themselves as criminals. It is their respectable persona which they use to mask the underlying deceitfulness inherent in their activity. Ultimately, white-collar criminals often tend to abuse occupational trust. Whilst conceiving their real self, they con by reference to their background, profession or business position, their dress, membership of societies and associations, and the public nature of donations to causes. Society has had them in the past, and society has them at present. Before I move on to the second question, I have not as yet given you any idea as to what is regularly or usually considered to be white-collar crime. There are several of them, and later when I mention some statistics given to me by the Director of Public Prosecutions, you will see that there is some uncertainty at the edges as to what might fall in or might be excluded. But for sure, matters such as security violations, antitrust violations, bribery, bank embezzlement, mail, wire fraud, tax fraud, and so forth, are clearly within the definition or description of white-collar crime. The second question is, who commits such crime? Can we answer that question by looking at the gender of the individuals involved? Any information from the age of those who do it? What about race? Does education play a part? What about background? Undoubtedly, general wealth, status and influence do. When discussing white-collar crime, one may talk either about corporate responsibility or personal responsibility. As there are obvious limitations on the utility of imposing criminal liability on companies, one may doubt the effectiveness of such a policy. A company cannot be blameworthy in the sense that it lacks the capacity to appreciate the harmfulness of its wrongdoing. It is not a moral agent and is incapable of emotional sensitivity. This being so, it is pain immune from deterrence and cannot benefit from rehabilitation. Further, establishing mens rea is rarely easy and frequently compromising. Could it be truly said that a company intentionally commits an act or omission, or is reckless or negligent to such end? If and when these obstacles can be overcome, it then needs to be asked what a criminal conviction additionally means when recorded against a company. One example may illustrate. It may be that persons with criminal records are prohibited from dealing with government contracts. If similar circumstances applied, how would one deal with a company? In the same way, many of you might argue. But such a move would also affect the innocent public and the innocent employees, suppliers, and subcontractors of that company. The law does not aim to punish the innocent. A company is an immortal entity. It will not die a natural death. How long, therefore, should a conviction continue to linger over its corporate soul? It seems to some, and it seems to me at least strongly arguable, that civil, regulatory and enforcement sanctions are more than adequate when dealing with companies which have breached corporate norms or made gains from illegal acts. Ultimately, in my view, only actors within a company can truly commit criminal acts. The general law on vicarious liability would not impute criminal liability to an employer if an employee committed traditional criminal acts whilst on duty. After all, as famously put by Lord Chancellor Thurlow in about 1775, corporations have neither a body to kick nor a soul to damn. Lest in case you believe that I think nobody should be responsible, that's not so. Of course, those who are responsible must be brought to bear, certainly where harm or even death has occurred. When that happens, however, there is a call to punish, and rightly so. But what is important is that the offenders must be those who are, in fact, responsible. In those circumstances, a person may be called to account and nothing further is gained by damning an incorporeal entity. That is not to say that a conviction would be easy, as several cases in England with regard to corporate manslaughter have shown in the recent past. In any event, I have digressed slightly because I'm more concerned with looking at real persons rather than continuing the above discussion. It is, after all, this is why real persons are so critical to this topic, the social status of the offender which primarily draws attention to white-collar crime, the social status. Whereas, in fact, it can be either the offender or victim with regard to white-collar crime. We have seen a ready example of it in the recent past with some high-profile prosecutions in the Central Criminal Court, including the DPP v. Lillis. White-collar persons are considered, at least by the general public, to be of the higher socio-economic means, persons who would tend to be a director, manager or owner of a company or business. It is true to say that there is general perception such persons are educated, intelligent, affluent, confident or sufficiently qualified to obtain a position, i.e. employment or occupation, with influence, such influence affording them opportunities for illicit gain. They are generally successful men, believe it. Man is the overwhelming culprit in this area, who have risen to the top of an organization and made large amounts of money in the process. This is the public perception of Mr. White Collar, the white middle-aged businessman. There are several notable examples, all of which you can commonly find in the press on a daily basis. Nevertheless, as I've said previously, crimes classified as white-collar can be committed by a broad spectrum of society. Is it really the case that all white-collar criminals conform to the stereotype description which I have above given? Do even the majority? The answer, in fact, is partly yes and partly no. The only statistics which I could lay my hands on of some value came from a study carried out by Aula in the 1980s, which concentrated on the demographics of white-collar offenders. It showed firstly that white-collar criminals were overwhelmingly male, over 85% of them, when compared to blue-collar criminals, only about 68%, and the general population. The average age was also higher, 40 instead of 30. The study suggested that race, at least in America in the 1980s, was a major distinguishing factor between white and street crime. About 8 out of 10 white-collar criminals were of that colour when compared with only about 1 in 3 of the population dealing with blue-collar. It was therefore the case that whites were overrepresented in white-collar crime and underrepresented in blue-collar crime. It's not important to dwell any further or in any great detail on these stats, but they do illustrate that regardless of the source country, although of course an indigenous population clearly would have a significant influence on the scale of the differential, males to a certain age are very much the prototype of the person involved in white-collar crime. Education was another area covered by the study. It dealt with both access to secondary and third level education, and the details showed a slightly different story. Although there was a marked difference in the former, i.e. secondary education between whites and blue collars, 80 as against 45%, when compared with the general public, there was little difference between white-collar criminals. The number of white-collar criminals recorded as having third-level education is still less than a third. It would therefore appear from these stats that white-collar criminals are not significantly better educated than members of the general public. Granted, they are more so than the blue-collar criminal, but that is to be expected. However, the stereotype of the white-collar criminal as being much better educated would appear to be somewhat misconceived. That may not be the situation today, given the fact that access to third level is much more available, and also, of course, it must be borne in mind that the stats which I've used, and the only I could find, are about 20 years out of date. Employment was another factor considered by them, and once more there was a marked difference between white and blue collar offenders in this area. The study looked at a basket of crimes and included antitrust, securities, tax, bribery, credit, false claims, mail, and bank embezzlement. I won't actually go through any of the results with you because it would take too long. However, just a few comments. There is a most striking divide between antitrust, securities fraud, tax and bribery on the one hand, and credit fraud, false claims, mail fraud, and bank embezzlement on the other. The former group to a great extent is white, male, over 40, and of relatively high means, whereas the latter are less likely to be white, less likely to be male, less than 40, and of low income. The contrast is particularly sharp between antitrust violators and bank embezzlers. So, as one can gather from that study, the answer to the question as to whether or not the prototype of the individual who was thought to be involved in white criminal, whether that's in fact borne out by the study, the answer is a partial one only. The third question is, why do such people get so involved with this type of crime? Is it resulting from the psychology of themselves, their personality, or organizational matters involved, or are they motivated by rational economics and nothing else? One might also ask as to whether such crimes are deliberate or inadvertent, negligent or reckless. Why do persons who live long professional lives, who have earned large amounts of money, commit acts which inevitably jeopardize their clean slate and their livelihood? Is it more readily apparent why those who engage in mail and credit fraud and bank embezzlement do so? It is, of course, more readily apparent. Such persons appear much closer to ordinary blue-collar criminals in their background and means. However, why do those who commit antitrust and securities violation actually do so? Again, Ross, when he was writing about criminaloids, said, "The key to the criminaloid is not evil impulse but moral insensitivity. Nature has not foredoomed them to evil by a double dose of lust, cruelty, greed or jealousy. They are not degeneratives tormented by monstrous cravings. They want nothing more than we all want. Wait for it. Money, power and consideration. In a word, success. But they are in a hurry and they are not particular as to means. Therefore, their criminological activities cannot be explained simply by their impoverished or damaged upbringing, or be attributable to a feeble or psychopathic mind. Indeed, it would seem that this is very much the case. Many white-collar criminals do not look upon their actions as criminal. I have already so said. They prefer instead to refer to it as an honest mistake, or that it was just the way business was done, or they all do it. You have heard all of these phrases before. You have read them constantly recently in the newspapers. Such persons deny that they ever intended to, or in fact did hurt anyone through their actions. Nor do they see such actions as morally wrong. Instead, they like to dress them up as indiscretions necessary in order for their business to survive. There may be other factors at play in play as to why such persons commit themselves to such acts. The personalities of the particular offenders may play a large role, and their experience, particularly of what might be termed elite white-collar criminals, would seem to show that such persons suffer from arrogance and a sense of superiority. Such superiority and arrogance leads a person to be used to getting his own way, and convinced of their own superiority, presume that whatever they do is the right thing, irrespective of other views, and even more significantly, irrespective of moral codes, norms, and of the law. There is the further motivation of what is being called ego challenge. That is the gratification which is gained from masterminding a complex challenge. I need say nothing further about this than refer you to Enron, which is a perfect example of this motivation in action. That company had to fool a large number of highly intelligent people into thinking that it was profitable, when in fact it was not so. It also had to be done in such a way as not to raise the suspicions of regulators, such as the SEC, investors, or industry analysts. The executives who managed to pull it off were clearly proud of their skills and very much enjoyed exercising them. So, can I just for one more moment inquire as to why people commit such white-collar crimes? I have discussed some of the social and personal traits of these criminal actors. I must ask whether the personality of the offender is the primary reason for the behaviour taking place in the first instance. First principles would suggest that personality traits alone could not be a sufficient reason to commit such crime. Many persons undoubtedly are arrogant and superior. Many are target achievers, ruthless and self-serving, but all do not engage in antitrust violations, security frauds, or other white-collar crimes. Indeed, often in the broader scheme, those few who are apprehended or characterized as rotten apples within the larger entity are said not to be representative of the whole, thereby absolving the latter. Their actions are portrayed as being motivated by greed, ego-tripping, rivalry, or some other personal aggrandizement, rather than on the opposite side of it, which is hunger, homelessness, poverty, addiction, or other need assumed to motivate many street or ordinary criminals. With corporate offenders particularly, there is often an assumption that offences have been committed because the company has prioritised profits over its loyal employees, over the state of the environment, or over the general health and welfare of the public. Indeed, such an assumption would seem logical, and in most cases represent fact. After all, profit is the primary purpose. Nonetheless, on other occasions, we have examples where such white-collar offenders have not directly benefited from the crimes themselves. You will remember Nick Leeson, who brought down Barings Bank, and you will also remember John Rusnak, who cost AIB some $600 or $700 million. Both allege, and I think it's accepted, that they did not individually profit from what they were doing. Nonetheless, could anybody suggest they do not fall within the category of being Mr. White criminal? Sutherland was unimpressed by generalized theories, suggesting that the underlying studies giving rise to such theories had a fundamental omission within it. They neglected white-collar criminals. He had no time for such studies. Notwithstanding the above, there is still a great tendency to account for misdeeds by reference to the rotten apple syndrome, which in fact, of course, is simply a method by which the entity as a whole can present a better face, be portrayed in a more respectable manner, and in fact distract itself from the perpetrators who very frequently were acting on their behalf. There are several other theories suggesting why individuals engage as they do, but I do not have time to mention those to you. It remains of ongoing interest to try and identify the ultimate reasons as to why individuals would in fact act in such a manner and jeopardize not only their individual integrity, but the integrity of their close family and of their close friends. Some might say that risk-taking in business would justify it. And indeed, some might say that there are directly logical reasons to embark upon that conduct if, in fact, having done a cost-benefit analysis, the gains anticipated will far outweigh any potential sanctions that might be imposed. I leave that topic for the moment. The next question is whether or not white-collar crime is victimless. If it is not worth victims, what type of crimes are committed? Where does the loss stop? And what effect does the loss or crime have on the victim? It has often been said that such crime is victimless. Otherwise, those who are directly affected by it have in some way, or otherwise it is said that those directly affected by it have in some way invited the misfortune upon themselves. An example of which would be an investor who seeks large returns in a risky venture, having previously engaged with a certain level of culpable knowledge. For the organised victim, for example, a company or public institution which is the victim of embezzlement, likewise there is little sympathy and even still less understanding. This lack of appreciation, indeed even interest, for the victimization called by white-collar crime only stands to reinforce a belief that there is public ambivalence towards such crime. However, ladies and gentlemen, can I immediately inform you that this type of crime is anything but victimless. Its harmful consequences, in fact, are society-threatening. It is therefore entirely proper that there exists a large body of literature which attempts to outline the vast and far-reaching damage which white-collar crime inflicts upon all of us. Some have suggested that the overall cost to society in this regard is far greater than from ordinary forms of crime, and therefore, by reason of such grounds, much more criminal in nature. The FBI in the US estimates that it costs the US economy over $300 billion annually. Unlike street crime, which has specific and readily identified victims, white-collar crime often victimizes universally, silently, insidiously, and indiscriminately. The apparent, though not real, victimless nature may only arise because the damage is diffuse, spread over multiple victims, each only perhaps suffering minor loss. Unlike ordinary crime, furthermore, the victim may not even know they have been victimized. Imagine an employee or an executive in a bank setting up an account to skim 0.1% of every transaction. Very few customers would miss it. And yet the perpetrator, by the sheer scale of his repeated activity, would find himself overwhelmed by his wrongful gains. Thus, although each victim would not necessarily identify what was happening, the individual perpetrator would gain profitably and greatly. Ultimately, though, it cannot be denied that all forms of white-collar crime do have victims. The victims may not know that they are being victimized. Even the perpetrators may not know specifically who the victims are. Nonetheless, they are victims. Kroll identifies 6 types of victims and furthermore mentions the type of crimes committed particularly against those victims. Very briefly, the government, tax evasion. An interesting statistic. Deloitte and Touche estimated that the cost of tax dodging between 1976 and 1996 in the UK was 2,000 billion sterling, 6 years government expenditure. Enron, that company I mentioned a moment ago, over a 5-year period avoided paying well over 400 million US dollars in taxes. The second group, the target of white-collar crime, are organizational victims who suffer from embezzlement, employee theft, fraud. The third is investors and share and savers. You might remember, ladies and gentlemen, that there was a scandal in the US a number of years ago involving savings and loans. And it is more or less accurately now accepted that up to $1.5 trillion was the cost of that scam. The fourth group are consumers who are subject to fraud, personal injury claims and cartels. Then you have workers and employees, and you have the general public. It can thus be seen that white-collar crime, far from being victimless, affects almost all levels of society, and its harms are pervasive. It can have far-reaching consequences and impact, resulting in extreme cases in injury, ill health and death. Further, it has been verified that even where the primary harm is economic, there may be emotional effects. Victims of fraud may feel bitter, angry and or depressed. They may suffer general health problems and loss of work. Worse still, sometimes they blame themselves or feel let down by the breach of trust. In order to further, in contrast to most ordinary crime, with the obvious exception of international organised crime and its associated activities, drug and people smuggling, the effects of white-collar crime and its victims may be global in scale, being both transnational and international. With increasing globalization, the effects of white-collar crime can only spread. Levi notes that frauds committed in and against developing countries may have massive effects, inhibiting economic and social development. That is, through the embezzlement or misappropriation of development funds, tragically in a lot of cases by the leaders of those very countries. Finally, in this context, it might be thought that the whole ambit of victims could possibly suggest indiscriminate victimization. What might be so in certain types, as both the well-off investor and the large corporation are obviously marked for fraud. Yet it would appear that white-collar crimes disproportionately affect those of lower economic status. Crimes against consumers are more likely to affect the less well-off. The rich have no need, at least up to now, to buy bargain-based products, second-hand cars, or fake replica merchandise, nor do they need to employ cowboy builders to keep their costs to a minimum. Similarly, most victims of workplace deaths are manual labourers, not managers, typically working in a small, non-unionised business. So, in fact, whatever the spread of target might be for white-collar crime, there can be no doubt but that the less well-off, those who are rightly categorised as being in the lower grouping of socioeconomic performers, are affected by far the worst. The fifth question is punishment. How should white-collar crime be punished? Through fines? Through imprisonment? How does the nature of the punishment affect the offender? How are white-collar criminals actually punished? Does punishment fit the crime? Is there an alternative form of punishment which might be better? And what's to be said for compliance versus punishment? As noted at the start, white-collar crimes includes both criminal and regulatory offences. The punishment of these two classes can be easily divided: imprisonment versus fines. There has been discussion for a long time as to which is the best option when dealing with such crime. Up until relatively recently, many white-collar crimes were purely regulatory. There has, however, now been a move towards increased criminalisation. Take, for example, competition cases. The 1991 Act introduced regulatory offences relating to anti-competitive agreements, cartels, and abuse of dominant position. Believe it or not, at that point they were not, in any technical sense or any sense, crimes. They were illegal, but they were sanctionable only through civil fines. However, the 1996 Act criminalised cartels. Anyone who entered into, made or implemented an anti-competitive agreement or engaged in concerted practice would be guilty of an offence, and on indictment subject to 2 years and a fine up to 3 million Irish pounds or 10% of annual turnover. In 2002, the term of imprisonment went from 2 to 5 and 3 million went to 4. It is worth noting that in both cases, however, only what might be described as hardcore cartel activity were subject to potential incarceration. Although abusing dominance was designated as a criminal offence, no custodial sentence was produced for the violation thereof. So one should ask, is the abuse of a dominant position therefore truly criminal? True, one could obtain a criminal conviction if found guilty of such an offence, but no matter how grave the harm or no matter how substantial the loss, the sanction was purely monetary. Some have wondered if this is indicative of ambivalence towards white-collar crime. Others have not found it easy to understand why a person could be imprisoned for cartel offences but not for abuse. If anything, such abuse would be closer to traditional crime than the cartel offence, simply because it is one where the victims are readily recognisable. There may, of course, be a rationale why that is not the case. The victims of cartel are unlikely to know that they have been victimised and are therefore unlikely to seek redress. Consequently, enforcement may, more appropriately, be a matter for a public agency, i.e. the DPP. On the other hand, those who have been abused by a dominant undertaking can take civil action to defend themselves. In any event, once more I digress. And back to what is the most appropriate way of dealing with white-collar offenders, jail or fines. It is clear that those white-collar crimes, most like theft, for example, embezzlement, are likely to be criminal. However, as illustrated with regards to competition crime, many economic frauds were not, or have not as yet been, criminalised in many jurisdictions. Many commentators who push for greater criminalisation point to the argument already outlined that by merely imposing fines on individuals or companies which commit such crimes, it allows the perpetrator to financially calculate the up and downside of engaging in those acts, and depending on the outcome, to commit or refrain. This means that rather than being considered as a deterrent, fines, even substantial ones, are pragmatically speaking not much more than a licence fee to engage in the prohibited action. It's well worth anybody's while who's interested in this area to have a look at Riordan, who published an article about this, in which he clearly and demonstrably indicates that cartel activity is and properly should be viewed as a crime. Therefore, the chance of sanctions is a major issue for the white-collar criminal. Ultimately, fines, in order to have a sufficient deterrent effect, would have to be set unreasonably high. This to the point where insolvency or bankruptcy may be the likely outcome. This would be an unacceptable situation, not merely to the company and its executives, but to the court. Companies may have significant number of employees, and it would seem unjust and inequitable to vicariously punish such persons. And even then the intended effect would depend largely on the long-term loss to the actual participant. A balance must therefore be struck between deterrent and survival. When dealing with ordinary criminal sentencing, a number of theoretical bases are advanced as justifying or explaining its purpose. These are retribution, rehabilitation, deterrence, and punishment. In sentencing for white-collar crimes, it has been recognised that these factors may have to be adjusted differently when compared to ordinary crime. Retribution is obviously not a factor. Rehabilitation relates primarily to those who reoffend. Deterrence, as we shall see, is considered the most significant theoretical basis. Punishment, too, is an important consideration. Deterrence may be categorized as being predicted upon three factors: severity, expedition, and certainty of punishment. Many commentators have noted that deterrence prevent first-time offenders. Many commentators have noted that deterrence to prevent first-time offenders is the main goal, if not the major purpose, of having a potential custodial sentence for white-collar crime. Indeed, white-collar offenders, unlike most hardened criminals, may be particularly affected by the deterrent effect of imprisonment. They are not committed to a lifestyle of crime, are risk-averse, and have more to lose as a result of criminal conviction than street offenders, many have said. Gies has noted that jail terms have a self-evident deterrent impact upon corporate officials who belong to a social group that is exquisitely sensitive to status deprivation and censure. That is a phrase that should stick in our minds. And in fact, the prospect of imprisonment may even cause health problems and significant distress to company executives, and therefore it might be hard to underestimate the fear and deterrent effect which a potential jail sentence may have on some. Although it would seem obvious that potential imprisonment should have a deterrent impact, empirical research into the actual effect has produced mixed results. A study of price fixing in the bread industry in the US found that civil actions against companies were a more effective, specific and general deterrent than criminal prosecution. An Australian study on nursing homes found that the only true deterrent factor was the probability of state detention. On the other hand, a recent study found that both formal sanctions, which included civil and criminal enforcement, and informal sanctions, for example, social censure, shame and the loss of respect against individuals, had a very strong effect on whether MBA students and corporate executives would engage in illegal activity. There is a further factor that white-collar criminals do not, which is that white-collar criminals do not wish to end up in the same jail as ordinary criminals. And indeed, many societies provide for that, but not in the way in which it has been explained. Many white-collar criminals end up serving their sentences in minimum security prisons, which mean that often white-collar criminals do not fare too badly. Once over the initial shock of incarceration, such offenders tended to adjust well to prison life. Further, white-collar offenders seem to possess the personalities and resources to cope in prison, much better in fact than street offenders. Moreover, upon their release, they are likely to return to the brotherhood and obtain similar jobs as they held prior to conviction. Although this would appear more representative of the business section than the professional or public sector. Unfortunately, it is not possible to say much on this point as it affects those incarcerated in this jurisdiction. Whilst the Irish Prison Service publishes annual reports, the last being for 2008, the same does not differentiate between different crimes in such a way that gives information on either white-collar crime or whether any inmates are white-collar criminals. However, anecdotally, one might be correct in assuming that, in fact, given the nature of the offenders and their non-violent offences, it is likely that such would be the case. In other words, that they would serve their sentences in one of the 3 minimum security prisons we have. In those circumstances, one might ask, would prison really be that bad for a corporate executive or a professional? Regardless, it would seem to me that a higher probability of detection, a higher probability of prosecution, and a higher probability of jail sentence will undoubtedly increase any deterrent effect. Whether or not that deterrence will be effective is a different matter, and ultimately will depend on the level of sanction. One or two other aspects of this punishment. Another aspect of it is shaming. Corporations are particularly conscious of their public image and have a vested interest in appearing respectable. So-called publicity orders may be made against companies or individuals, requiring them to publish apologies or corrections, or else they may be required to call press conferences to announce their non-compliance and to suggest what program they have in existence to make sure they will not be a repeat. Yet, despite all of that, there is undoubtedly some ambivalence in respect of punishment relative to white-collar criminals. There is an attitude amongst many enforcement agencies that a hard stance on white-collar crime may be counterproductive. Cartels, for example, can be very difficult to uncover. Many white-collar crime is deliberately shrouded behind corporate doors where the general public or regulators may not tread. Over-enforcement, it is therefore felt, may drive such acts further underground and may even heighten a sense of persecution amongst those industries most targeted, making, of course, cooperation or making use of any leniency program much less likely. So what have enforcers done? They have sought to concentrate on compliance over enforcement and treated the latter as a last resort. Of course, this may be driven in part by the undoubted fact that true enforcement in a complex case is costly, and pragmatically speaking, such agencies have limited resources for prosecution. Compliance is therefore seen as being much more cost-effective. A knock on a door from the regulator may be sufficient to get the errant company to fall in line, thus saving time and effort in prosecution for the regulator and saving the company from the inconvenience and publicity of enforcement action. And despite all of that, the treatment of white-collar crime through compliance measures again highlights the different approach to white as opposed to blue-collar crime. The other section I've dealt with is public perception and the future. And there has been Several studies in the US indicating that they have a significant policy in existence dealing with this matter. I don't propose, in fact, to go into that in any depth for the moment. A quick word about one or two other matters, and then I finish. Firstly, about investigation. The nature of white-collar crime, in particular its secretive nature and the fact that victims may not be aware of their victimization, makes it particularly difficult to discover and investigate. In these respects, the traditional methods of criminal investigation may be insufficient to properly deal with white-collar crimes. To combat this, there has been significant moves in the US recently in the way in which white-collar crimes are being investigated, with electronic surveillance now being widespreadly used with court sanction. Referring to market abuse by such entities as hedge funds, and trying to identify wrongdoing in that regard is almost impossible, because so many punts are placed at a time with hedge funds that the traders can always argue that they got lucky. So it would require a case not frequently passed upon before, in fact, one would have sufficient information to even consider sending a file to the Director of Public Prosecution. Some commentators at this moment in time have noted that the detection and enforcement strategy for white-collar crimes is now more akin to that used for mobsters and other organised criminals. The FBI has included a particular section on white-collar crime in its strategic plan for 2004 and 2009, with its ultimate goal being to reduce the level of that type of crime and thus to save the state a very significant sum of money. It may be that similar moves to those in the US may be seen in this jurisdiction. The government, in the Renew Programme for Government, published in October 2009, noted that in relation to justice and crime, it, quote, will ensure that every effort is made to pursue perpetrators of white-collar crime, including financial irregularity and institutional criminal malpractice, and to ensure that the Criminal Assets Bureau has the appropriate professional and expert staff, including forensic accountants, auditors, risk assessors, and IT experts. This item was included in the Programme for Government Renewal, following comments made by Mr. John Gormley, TD, as Minister for the Environment, when he noted that there was a need to utilise the criminal law more against white-collar offenders. He called for such offenders to be, and I quote directly his words, to be led out in handcuffs, and he cited the United States in his justification. In mentioning this, I am not to be taken whatsoever in offering any view on it. I'm simply pointing out that there seems to be some activity at government level with regard to white-collar crime in general. I should mention that, of course, it would not be desirable, I think, for there to be an overnight, widespread and wholesale commencement of such matters as electronic surveillance on businesses. It would have to be dealt with on an individual basis, and presumably there would be sufficient and are sufficient safeguards in the relevant legislation that complying entities would have no need to worry whatsoever. White-collar crimes undoubtedly are potentially significantly more complex in nature than ordinary crimes. The investigation is much more difficult. Nonetheless, strict and constant enforcement must be encouraged. Only through this can a balance be struck between deterring criminal conduct and preventing any chilling effects such enforcement might have on legitimate business interests. In preparing for this talk, I requested information from both the DPP and the Gardaí to see if they had any relevant statistics on white-collar crime. None significantly from the latter. The DPP provided a list of crimes which he considered to be white-collar since 2000. Many of these, however, may not truly be white-collar, rather they are offences of a non-violent and financial nature, often related to fraud or revenue offences. They may, of course, be white-collar, but unfortunately, it is not possible to tell conclusively. It is also difficult to see any specific trends within the results due to the low total number of crimes listed. However, it would appear that 2006 was a particularly busy year for competition crimes, with 9 persons being tried on indictment in the Central Criminal Court and 5 in the Circuit Criminal. Most of these arose out of car-dealing cartels. Unfortunately, the current reporting system for crimes is not really sufficient to extract information necessary to give any real view as to the full nature of white-collar crime committed here. So, ladies and gentlemen, there is very little, in fact, available by way of hard evidence in this jurisdiction from the Office of the Director or from published material by An Garda Síochána, which will be of assistance in this regard. However, if one looks at the various enforcing agencies which operate in this area, you also have the courts. And the courts have, in the past a number of years, expressed strong opinion on matters relating to white-collar crime. And certainly, those opinions would seem to indicate that whatever allegations of ambivalence might be available against any other entity, and I'm not suggesting there is any such ambivalence, it most definitely cannot be ascribed, I think, to the current state of legal enforcement as expressed in the opinion of judgments given by the Central Criminal Court. In conclusion then, there must be recognition by both the public and national governments that white-collar crime is serious. It can have a significant impact on the well-being of individuals and the economy as a whole. Further, I think that by this stage most persons engaged in business should be aware of what they should and should not do. These laws, as I noted at the beginning of this talk, although not necessarily in the same form, have been around for hundreds of years. The exploitation of the public or competitors through business practices has long been considered morally wrong, if not legally so. I would hope that in the future the perception of the white-collar criminal as a respectable criminal will give way to an acknowledgement of the damage of white-collar crime and the fact that persons who engage in it must not be allowed to get away with it. Thank you very much indeed, and I'm sorry for keeping you so long.